So here's a question we hear a lot in Wisconsin. Can your employer make you sign a non-compete agreement even if you've already been working there for a couple of years? The short answer is yes, your employer can require it, and if they refuse, they can fire you. That's because most employees are at will, which means you can be let go at any time for almost any reason. But here's the catch. Just because an employer can make you sign one doesn't mean that the agreement is enforceable. I'm Kevin O'Flaherty from O'Flaherty Law, and in this video we're breaking down how non-competes work in Wisconsin, what makes them valid, and what's happening at the federal level. First off, a non-compete is simply a contract where you agree not to work for a competitor, or even start a similar business yourself, for a certain period of time and in a certain geographical area after leaving your job. For it to be enforceable in Wisconsin, it has to pass 5 tests. It must be necessary to protect your employer. It has to have a reasonable time limit. It has to cover a reasonable territory. It can't be unfair to you as the employee. And it can't be unfair to the public. If even one of those factors is unreasonable, the entire agreement is void. For example, it might be reasonable for a company to stop a computer programmer from working for a direct competitor within 75 miles for 6 months. But it would be unreasonable to block that same programmer from working for any tech company anywhere in Wisconsin for 3 years. Courts here don't rewrite non-competes to make them reasonable. They throw out the whole thing. That's because public policy favors worker mobility. Now, non-competes are more likely to be upheld if the employer gives you something in return for signing, like extra training, tuition payments, or stock options, because that makes the contract feel more like a fair trade. What about federal law? Back in April 2024, the FTC announced a nationwide ban on non-compete agreements, but that rule was struck down in Texas and Florida courts before it even went into effect. Those decisions were appealed, but the new administration put those appeals on hold, so right now there is no federal ban. That could change in the future, but as of today, Wisconsin law still controls. So bottom line, yes, your employer can require you to sign a non-compete, but whether it will actually hold up in court depends on how reasonable it is. If you're being asked to sign one, it's a good idea to have an attorney review it so you know exactly what rights you may be giving up. If you found this video helpful, stick around for the next one on screen. It tackles another real-life legal situation we see often. Until next time, take care.